Thank you for joining us to watch the resources that are being made available for heirs in a series of heirs resources that is rolling out with the heirs property relending program. My name is Kanika Davis, and I am a national outreach specialist with the United States Department of Agriculture Farm Service Agency. I have with me today Sarah Campbell and Rusty Romley, who is an attorney with the National Ag Law Center, and they will both introduce themselves.
Hi everyone, I'm Sarah Campbell. I'm USDA's Beginning Farmer and Rancher Coordinator, so I work on beginning farmer and rancher issues across the department, including land access. And so that's why I'm here working on some of the heirs property relending efforts, and I'm looking forward to having this conversation with Rusty today.
Well, thank you. My name is Rusty Rumley. I am a senior staff attorney here at the National Agricultural Law Center, and I do a lot of work on issues regarding land use and estate planning. So that's kind of my ballywick.
Thank you both so much. As we dive into these resources today, I just kind of want to explain why we are providing this. FSA has been in the process of rolling out resources for heirs since the 2018 Farm Bill. A part of those resources are the language and legislation that was approved for the county offices to work with heirs that come in that are seeking to receive a form number. We also have the avenue for heirs to work with the heirs property relending program, where they can work with those announced intermediary lenders that are there and available. At this time, we have 3, but the announcement is a rolling announcement. So you can feel free to check back on the farmers.gov/heirs website in order to see any new lenders that are being announced. We also have the certified mediation program, where heirs can work with certified mediators that have partnered with the USDA to provide those services within those states. And on the farmers.gov/heirs website, you will see a link to that certified mediation program fact sheet, where you will be able to identify what certified mediators and certified mediation services are available within your state. Today we have with us Rusty Rumley, and we just want to thank him again for taking the opportunity to sit down with the USDA Farm Service Agency just to provide some guidance as we're looking for this heirs property program just to roll out not only the heirs property relending program, but also the different aspects, as we talked about, the county offices as well as certified mediation program. We know that a lot of heirs have questions like where to start, what are some things that they need to do when they first have found out that they have heirs property, and things of those nature. FSA has partnered with different organizations as well as heirs expert in the heirs property field. And as a part of that, Rusty is just going to provide some information today that we would think is very helpful for heirs to know and think about as they look to resolve some of their heirs property issues. So at this time, we'll get this conversation kicked off and started. So one of the first things that we wanted to ask Rusty, as we were just looking into some advice and information that heirs could be provided, is for individuals that have inherited heirs property, Rusty, what are some pointers that you will provide them once they have realized that they don't have this clear title and their land is truly heirs property?
That's a really good question. So first of all, let me start with saying at the Ag Law Center, we're not allowed to provide legal advice, but we can provide legal information. So these are more of like tips and things to be thinking about ahead of time, but at some point you're probably going to need local counsel to help with these issues, depending upon how complicated the matter is. So for people that are just getting started, one thing that I think helps is really helpful to find out what are the baseline facts. So how much land do you own, or how much land is at issue? Property lines can move over time. People can think they own more or less than what they really do. And that's even for property that's not heir property. So finding out, just how much land is at issue is going to be important. The second thing that I think is really important is to go back and see, well, who's the last person that had clear title? It might be a parent, a grandparent, a great-grandparent, depending on how far it goes back. And then start doing your research on finding out who those potential heirs are. who are all the potential co-owners. And I really can't stress enough, it's important that you go in there and start from scratch. Don't be making assumptions on who people are, because it's very common in families to refer to someone as a cousin or an uncle, and they may not be blood relation. They may just be close enough to you that it's just, the family calls them that. So it's really important to go back there and actually look at the records and see, is this person actually a blood relative? Because they may not be. And vice versa, there could be someone that is a blood relative that just wasn't talked about very much. Maybe they died a long time ago. Maybe there's some other reason they're not talked about. But it is really important to go out there and establish, how much land is at issue, and then who all are the potential heirs at law.
Thanks, Rusty. And I have a follow-up question. You mentioned that you all kind of can just share information, and that, somebody really probably does need to be will eventually need to be working with an attorney. I'm assuming somebody who's barred in their state. But when an heir gets to that stage and when someone is looking to work with an attorney, what guidance would you share with them on how to select that attorney and vet them?
So that's always tricky. So one of the issues that we run into with heir property is there's no two pieces of land in the entire world that are identical. And there are no two families in the entire world that are identical. So you're pairing up two very unique things. So you always end up with a unique problem. It's never going to look the same one situation to the next. So that's usually why it's important to have an attorney involved, because there's not really a cookie cutter way of doing this. Who does this is going to vary widely depending upon what state you're in. Some states do have resources that are available to help owners of heir property. Other state, some of it with some of the legal work. Other states, the options may be more limited. Generally, though, you're going to be looking for an attorney that's had a little bit of experience with land work, so like title work, things like that, and with estate planning. And a lot of your general practice attorneys are going to have some experience with that. Especially if it's farmland, another good option would be, usually there's a couple of lawyers at least in every county that works with the local farmers, whether it's buying and selling land or with USDA programs or something. Going and talking to one of those attorneys is another good option. And if you can't find one of those attorneys, most people can identify the coffee shop where the farmers hang out in the morning. Go down there, buy the farmers a cup of coffee, and kind of poll the crowd on who they use. You might be able to get a couple of names that way. But it's generally going to be a little bit cheaper to get a local attorney, just because they're not going to be someone that's having to travel back and forth to the county, because most of this stuff is going to be done in the county where the heir property is located at. So having that local attorney will help. Sometimes you may have to go farther out. Sometimes there may be attorneys that are willing to help that are located farther out. But that's going to be part of that initial legwork that the families have to do to start the process to resolve this issue.
Thanks so much. So as we are kind of just thinking some more things through, like what would be some helpful things heirs could do to make the process for resolving those heirs issue a little smoother? I know you talked about identifying who might actually be a cousin versus who is not by blood, but are there any other tips within that realm that you would suggest?
Honestly, that's probably one of the most beneficial things that the heirs can do, is try to figure out, who's who. I think depending upon how complicated the situation is, this could take a little bit of time. If the heir property was created when someone's parent passed away and there's, 3 siblings, it doesn't take a whole lot of legwork to get that established. But I've seen heir property situations where it was the great-great-grandparents that passed away and they were the last legal owners. So now you're talking about 50 to 75 potential co-owners. So at that point, it's a lot of legwork to go out there and determine who all are the legal heirs and trace it through each of those generations. So the amount of work that someone may have to do is going to vary pretty wildly depending upon just how many generations are in there, how many kids were born, how many of those kids had their own kids or they died without issue. Some of that stuff's going to be pretty tricky to do. Finding out, was a kid adopted? Were they a stepchild? If they were a stepchild, were they the stepchild of the descendant where the land went through? Like, there's a lot of potential issues. So creating that family tree is a big help for whatever attorney is going to be trying to address this issue.
So I know you just mentioned about making sure you have that family tree because that will help. When thinking about going the route of hiring an attorney, how beneficial is that tree? Like, because I know you go in and you tell someone, hey, I think I might only have 5 heirs, and come to find out it's like 10 of you all.
Well, they're going to have to try to find, they're going to do a little bit of due diligence themselves, hopefully. But like I said, it's not always easy. If it's only been heir property for one generation, it's typically not too hard. I mean, most people can list those off the top of their head. They may want to see birth certificates or some other kind of documentation to prove that. But things can get a lot more complicated if it's been heir property for 2 or 3 generations. So, I mean, really, it's going to depend upon how long has it been heir property, how many potential heirs are at stake. If it's just 2 or 3, it's not terribly difficult, especially if people, all the heirs agree. But as you add more people and you start getting people disagreeing on kind of what the ultimate outcome should be, that's when things get more complicated.
Yeah, Rusty, you talked about how some of the things that a lawyer can do and how they can do some of that background research and potentially assist with identifying errors that maybe they've missed. I guess to help kind of people manage their expectations, what kinds of things can lawyers definitely help with? And then what are maybe some additional responsibilities that heirs might have that a lawyer can't assist with?
So finding those heirs is probably going to be easier for the actual heirs themselves. I mean, they're the ones that are going to have access to those types of records. Sometimes it could be like old family Bibles where like births and deaths were recorded at the beginning. Sometimes it's going to be other paperwork or family photos. That's not things that a lawyer can typically find at the courthouse. So that kind of stuff is going to be important for the family members. Now, there are ways that different states have different ways to deal with heirs that no one may know of. So generally there's like a posting requirement. So for states that have adopted the Uniform Partition of Heir Property Act, you can post notice on the actual property that you're starting this process to resolve heirship, and people that think they have a claim should, get with this person. So it really varies on the state, but especially that family research, that's generally going to be better for the heirs because they're the ones that are going to have those types of resources and the lawyer's not. Different attorneys are going to have different things, especially tracking down some of those heirs. That can take a long time. Attorneys are going to be probably better equipped to handle things like the transferring title of the property, if it's a Uniform Partition of Heir Property Act state, taking it through that process. If the families are wanting to create an LLC at the end of the process to kind of put the ownership of that property into an LLC to prevent it from becoming heir property again, the attorney is going to be beneficial there. The lawyer is going to be more of doing the transactional type work, where it comes to like research for the family and things like that. It's the family is going to have the best source of records for that type of issue. The Uniform Partition of Heir Property Act is a model law that I think about half the states now have adopted. So what it basically does is it creates a framework for trying to resolve heir property disputes. So typically what would happen if you don't have Uniform Partition of Heir Property Act adopted in your state is that everyone that's a owner of the heir property is their tenants in common, which basically means everybody owns an undivided interest of that property. So if you have 100 acres and there's 10 owners, you can't just point to the land and say, person A owns this 10 acres and person B owns this 10 acres. All 10 of them own the 100 acres all together. So they all have the right to access all of the land. So it makes things confusing and difficult when it comes to things like building houses or things like that. So typically what would happen is if one of those heirs wants to get out of the situation, they want to sell their interest. The traditional approach is that because that land is divided and is held in tenants in common, it's really difficult to physically divide up the land. Because if you have 100 acres, different parts of that 100 acres is going to be worth more than other parts of the 100 acres. Some of it's going to be road frontage, so that's going to be more valuable. Some of it's going to be scrub brush, while other parts are going to be cropland. The cropland is going to be more valuable than scrub brush is. So it's really hard to equitably divide land. So what courts have done in the past as the simple remedy is, well, why don't we just sell the land, and then if everybody owns 10% of it, we give everybody 10% of the sale price, minus any expenses for selling the land. And that was kind of seen as the fair way to do it. Now, it also means that the family lost their land. And if the other 9 people wanted to keep the land, their only option was to show up on the sale day and try to buy it themselves. But they really didn't have any advantage that anyone else didn't have already. So Uniform Partition of Heir Property Act, what it does is it kind of creates more of a set of steps to first determine, well, how much is the land worth, and then determine, well, which ones of these heirs want out. So going back to that example of the 100 acres with the 10 owners, say 2 of the owners, they want out. They want their money. The first right would be, well, let's figure out how much the land's worth, how much their share is worth, and then are there any of the other current owners, those other 8, that can buy them out? Or do they want to buy them out? And if so, great. They pay their portion, they buy their shares, but the thing is the land's still in tenancy in common. So now you still have heir property, you just have heir property with 8 owners instead of 10 owners. So at that point, you've gotten rid of the owners, you've kept the land in the family, but you may not have fixed the situation because eventually those 8 people are going to pass away. Their heirs, their children, grandchildren, whatever, are going to inherit the land, and then you may have to start again. So, another step that the lawyer can help you with is, do you want to put this into some kind of entity, business entity, like an LLC or a trust or something like that, to make sure that this problem doesn't pop up again when the next generation of heirs come in. Because every generation that removed, they may have less and less of a connection to that property. So going back, so let's say they can't, there's no one that can buy them out. The relending program is supposed to provide money. This is one of the benefits of the relending program is this would be a place where you could potentially take out a loan to buy out the interest of those ones that want out. Suppose you can't get the loan for some reason or no one wants to buy them out. Then the court will look at, is there really any way we can physically divide the land? If there's a way people can agree to it, they'll physically divide up the land. At that point, it's no longer heir property. If there's really not a fair way to do it, and there's a whole list of factors that they'll consider if there's a fair way to do it. If there's no fair way to do it and none of the current heirs can buy out the ones that want out, then it'll be sold. But the court kind of gets to have a little bit of a say, and they'll try to pick the method of sale that's going to bring the most value to the owners of the property. So even the Uniform Partition of Heir Property Act, it's not a perfect solution for keeping the land in the family. Like there's got to be someone there, someone that's an heir that can buy those interests out, whether they've got the money themselves or whether they can get the loan to purchase it. But if nothing else works, the very last resort is to sell the property. Sorry, that's a very long-winded explanation of a convoluted statute.
No, thank you so much for that. That definitely with our audience, again, it's going to be individuals that are watching this today who just don't know where to start. So you have definitely provided them with a wealth of information. We really, really do thank you. Sarah, did you have any additional follow-up questions before we get ready to conclude here?
No, I was going to ask about kind of prevention and next steps, but Rusty kind of laid out some options about setting up a trust and LLCs. So to help heirs once they actually get clear title. So
the options are going to be different in different states. So that's another reason why you want local attorneys. Like I said, these things they're highly individual because of the unique aspects of land and then family. And then you add in that we have 50 different states with 50 different sets of laws. You really end up with some unique situations, and something that works great in one state with one family and one piece of land may not work so well in a different place with a different family. So it really is important to kind of treat these things as unique when you go forward with this.
Great. And that is just a good place to wrap it up on this one and tie that together. And again, like reiterate that heirs property issues are very unique. So trying to ensure that you take some of the information that was provided today to apply that to help, kind of get your situation kicked off, the research aspect of it, and if possible, trying to look for someone local that can assist you with that, and just understanding that, this is an issue that while it can be resolved, patience is definitely critical. Ensuring that you do your research to see if your state is one of the ones that fall under that Uniform Partition of Heirs Property Act that Rusty mentioned earlier, and seeing what resources that you have available for you. You will see at the conclusion of this video, link where it takes you to the farmers.gov/heirs website, where some additional information is there and some additional links that will also take you to other resources that are available. However, we hope that you were able to walk away from here today after watching this video and at least feel empowered to know some different guidance that is out there for you, some different places to start, some different things that you need to be thinking about, and just providing whatever legwork you can on your part to ensure that you start like connecting some of the dots of who is who, so that your property can go from being heirs property to just being having a clear title and clear deed. So we thank you for joining us today, Rusty, as well as we just look to provide a series of resources. This is the first of additional resources that will be made available. So we encourage you to continue to check back on our website to see when those updates have been made. But we thank you for taking the time out of your day to watch this video today and to join in on this discussion. Take care.
Thanks.